All right, wonderful. Thank you so much, Frederico, for joining us today. Ladies and gentlemen, my name is Romit Sarkar. I'm an Associate Counsel at IAMC. And we have with us today Frederico Singarajah, who is an accomplished barrister with Gatehouse Chambers in the UK, and is also a trained advocate from Brazil. Therefore, he represents, in the words of I'd say Miley Cyrus, the best of both worlds, from the common law and civil law traditions. And we'll see today how he brings these together in international commercial arbitration. Frederico's experience in this area is vast. He's acted, of course, as counsel and arbitrator as well. He's been impaneled with institutions across the world, from Vienna, Hong Kong, Korea, Brazil, and this is just to name a few. Frederico an area of law that he's not worked closely with, spanning each and every sector possible within these traditions. Frederico, it is such a pleasure to have you with us. Thank you so much for joining us today.
Thank you, Romit. Thanks for the very kind invitation. It's a real pleasure to be here to discuss these important topics with you and your audience.
Wonderful. So our dear audience, what we will do now is we'll quickly launch into a sharp Q&A, talking and touching upon major talking points based on your interests. And as we speak and discuss, please feel free to use the chat box and we'll make sure the chat box is enabled for you. But please do put your questions down on the chat box and we will take them up one by one as they come. If anything remains unanswered, we'd be happy to take them in the last 15 minutes of the session, which we dedicate to just Q&A. All right. With that, Frederico, why don't you start us off by telling us about just what the key differences are in terms of the different legal traditions, civil and common, and how they interact and come together in the sphere of arbitration?
Thanks, Romit. I think, international arbitration is a mechanism for the resolution of international disputes. And the reason it's become so successful, I think, is two reasons. Firstly, potentially because it is not ideal to have to submit to any particular jurisdiction's court when you have international disputes with parties from multiple jurisdictions. And secondly, because it affords that neutrality. And so in order to be able to function and work, there's been a number of sort of harmonizing provisions, if you like. I'd say the two main provisions are the UNCITRAL model law and the New York Convention, which anyone who practices in arbitration, international arbitration at least, will be very familiar. Now, what those two instruments try to do, first of all, is to harmonize the differences between civil and common law jurisdictions. The differences, I would say, between those two traditions are quite vast, but I just want to emphasize that there are differences even between civil law jurisdictions as well as between common law jurisdictions. So, England and Wales is different to the United States or New York, for example, which is its own jurisdiction, in the same way that French law and French traditions may be different from, let's say, Chinese French traditions and law, despite the fact that they're both civil law jurisdictions. So if I go into some examples, I suppose for me, one of the most notable examples is just the fundamental principles or the notions of justice. So in common law jurisdictions, there is, I think, a tendency, and I make all my observations, I emphasize that they're generalizations, okay? But for example, in common law jurisdictions, I think justice is seen to be achieved where there are, in an international transaction, transparent rules of engagement, let me put it that way. So as long as both parties understand what the rules are, then actually the economic balance of the parties is less significant. Whilst in civil law jurisdictions, I think they are more concerned in notions of economic equality, good faith, and other notions which we might see, if we come from a common law tradition, as paternalistic. And civil law jurisdictions may see common law jurisdictions or the legal system very much permissive of a free market. So that's sort of the macro. In terms of things that are less talked about, I know there are some obvious differences which a lot of people talk about in the context of international arbitration, but I just wanted to touch upon a few other things that perhaps are not as well known. Notions such as standard of proof. So we are very well familiar with the burden of proof, which is who has the onus of proving their case. Normally it's the party that makes an allegation, a positive allegation, but standards of proof. So those of us who have been trained in the common law jurisdictions are also familiar with the notion that the civil law standard of proof is the balance of probabilities. But those notions don't exist in civil law jurisdictions, generally speaking. A party must convince a judge or arbitrator to their conviction. So that's a significant difference. It may transpire and have real effect when you're dealing with knotty, prickly subjects like corruption or fraud or these kind of things. Then, we like to discuss the standard of proof, whether it's elevated, prima facie standard of proof, civil, balance of probabilities, etc., etc. Another notable difference, I think, is things like arbitrator selection. So in common law jurisdictions, I think that there is more of a tendency, for example, to choose retired judges as arbitrators. Whilst we don't really see that practice at all in civil law jurisdictions, what they tend to do is potentially select academics as arbitrators, which is not something we tend to do in the common law. And I suspect, although I don't know, but I think my theory is that civil law lawyers and common lawyers choose these people for the same reason, which is that they think they know which way they will lean. Because in common law jurisdictions, as we know, we have a system of binding precedents, and therefore we can read these judges' judgments and we can try and believe that we are able to think that these judges may lean in a certain way in respect of the dispute that we have before us. And the same is true for academics. Doctrines and academic writings are presented as evidence or as persuasive in civil law jurisdictions, and therefore if an academic has written extensively that they believe a contract should be interpreted in a certain way, or that this or that law applies, then again you may be able to favor your client or the party that you represent in that way. Again, in terms of sort of harmonization, there is lots of soft law as well, things like IBA guidelines on taking of evidence, the Prague rules, etc., which all try to harmonize the differences, some of the most stark differences between civil and common law practices and cultures. But I would say that ultimately, I think that one of the great advantages about international arbitration is the fact that it is quite a flexible mechanism, and certainly procedurally, it affords the parties the ability to tailor each and every arbitration to suit those particular parties, advocates, tribunals, whatever. So I think that's probably an underused tool of international arbitration. So I think that's probably a whistle-stop tour.
I think that's an incredible insight, and thank you so much for, of course, reminding us of the tremendous amount of flexibility that arbitration offers, just in terms of being a creature of contract itself. And I would say that this goes beyond legal systems and traditions, and whether it's ad hoc or institutional, arbitration itself finds itself to be remarkably adaptable to changing times. And I think we saw this when a lot of arbitrations went virtual during COVID. But what you also touched upon is in terms of strategy, of course, we can see that there's a particular reason the common law system would want to appoint retired judges, and on the other end, we have academics. Bearing this in mind, when you act as counsel in an international arbitration, what is the difference in approach when you have a tribunal that has a civil law background, a common law one, or, I mean, to complicate things even further, a tribunal that represents a mix of these traditions? What is the approach that you would take as counsel in a matter like this?
Yeah, thanks, Romit. That's a great question, I think. You know, in England, which is a very particular jurisdiction with a long tradition of oral advocacy, which perhaps is not shared amongst all civil law jurisdictions in the same way. However, I think, you know, we're now reached a point in international arbitration where we may have the first generation who actually studied international arbitration before practice. And therefore, what we have is a general hangover, if you like, of our international arbitration being an adaptation of whatever that advocate's litigation system where they trained and practiced is. So, you know, there's often a criticism that English lawyers will try and run an arbitration in a very English way, and, you know, an Indian lawyer may seek to run an arbitration in the way that litigation may be run in India, especially if you have two sets of Indian law firms, for example, or English law firms or whatever. And it's when you have that clash then of different cultures, as you say. So you have to adapt to your tribunal always, and whether they're common law, civil law, you know, a lot of international arbitration tribunals will be run in English, and if the tribunal's first language is not English, that will make a difference as to how you approach. And again, as you say, civil and common law. I mean, there are multiple differences. Cross-examination is one example. For example, how you might approach that if you have three civil lawyers is going to be very, very different to how you approach that if you have three common lawyers. And as you say, when you have a mix, that might even be different. But let's take a slightly different issue. Things like contractual interpretation. So, you know, a common lawyer will have a higher tendency to look at the contract, what we call the four corners of the contract rule. So they will be more minded, I think, to limit their interpretation to what is in the contract. Whilst I think a civil lawyer, because, you know, the main difference between civil and common law traditions is that civil law has civil codes of conduct, etc., procedural codes, etc. So they have a codified system of law, and therefore their contracts tend to be thinner, and a lot of law will be implied, a lot of obligations and rights will be implied by the civil code. And therefore, I think they are indoctrinated to refer back to legislation or civil codes or whatever it is. And so if your case theory, as it were, relies predominantly on not looking beyond the contract itself, then you may approach that differently with a common lawyer than you would a civil law tribunal. Of course, as you've already pointed out, I think when you have a mixed tribunal, then that becomes even more of a challenge. And it's very difficult to predict how a tribunal, how the power balance and how the influence of, you know, you may only have one civil lawyer, but they may be the loudest voice within the three, and vice versa. So it's very difficult to see how that will play. I think ultimately this is why when we emphasize training on advocacy, especially for international arbitration, we emphasize keeping things simple, having clear arguments, having clear case theory, all of these things. It's very much a back to basics advocacy course. I teach here in Gray's Inn, which is my Inn of Courts. We teach barristers how to deliver oral advocacy and written advocacy. I have a specific course just for international arbitration because I think there is a marked distinction between how you may deliver your oral advocacy in court in England to how you might deliver it to a mixed tribunal from varying jurisdictions, including civil lawyers.
All right, thank you so much for that, Frederico. And I think when you spoke to us about the differences in terms of the civil and common law system, wherein the civil law system is bound by code and legislation, I think it really comes down to that fundamental question that I think everyone grapples with at some point, which is who's really making the law here? Is it the legislature? Is it the judges who lays it down? And it's always important to see how even the most fundamental things come back full circle when we discuss something like this. Now, I'm going to pick up one of the questions from the chat box here, and I'm going to rephrase it a little, now that you also mentioned that you're an educator and a teacher at the bar. In terms of trying to make a career in arbitration and advocacy, because I gather we have a lot of students and they want to understand how they should intern, perhaps best approach people. I'm going to take that a step further and ask you that I understand that you coach your team from the Inn for this Vienna, if I'm not wrong. And what is the role that moot court competitions, especially ones that are international in nature, have in shaping the next generation of counsels and arbitrators, especially as you've already told us that we're currently in the first set of practitioners themselves who studied arbitration as a subject. What is the role of, say, moot courts, for example, that come into this in bridging the divide between different traditions?
I think it's fundamental. I'm a big fan of the Vismoot, as you've mentioned. I'm a good friend of Stefan Krolls. I think he's a great ambassador for that type of competition. I think so. There are two. Let's call it two layers, right? So you have domestic arbitration, and then you have international arbitration. And I think it is difficult to find anyone who practices arbitration who will not give you as advice, if you want to get into arbitration, learn to be a lawyer first. And you learn that either by doing court work or by doing domestic arbitrations. Some jurisdictions have large volumes of domestic arbitrations. And then we have the international arbitration world. And I would say that there are today many more people interested in practicing international arbitration than there are international arbitration vacancies, if you like. There are not that many international arbitrations in the world to be able to support everyone who wants to work in international arbitration. So therefore, it's incredibly competitive. And getting your foot in the door requires that, as I say, I think first of all, you qualify anywhere in the world. It doesn't matter where you're qualified, but you have to be qualified. I think for people to really give you the attention and take you seriously, that's number one. You should qualify somewhere. Number two, I think it is fundamental that you know how to be a lawyer, first of all. So learn contractual interpretation, legal research, learn how to draft documents, pleadings, statements of case, memorials, all of those kind of things. Learn the rules of evidence, learn if you can do oral advocacy in your jurisdiction, oral advocacy, learn all of that. Learn the disputes side of the law. And if you can, if you get into any kind of sectors, things like M&A, which is transactional, still produce quite a lot of arbitration practitioners and other areas. If you do energy law, if you do any of the things that infrastructure, construction, all big arbitration sectors, if you like, learn the law. And then, yes, absolutely. I think when you're studying and when you're qualifying, moot courts are fundamental for seeing what an arbitration is like, because of their confidential nature. It's very difficult to understand what an arbitration is actually like. And I think these moot courts are the closest thing to the real thing that you can get without doing the real thing. So I think they definitely provide assistance in that. Number two, I think for international arbitration, networking is key. And it'll give you an opportunity to meet other people who are also interested, at least at that stage, in potentially a career in international arbitration, but certainly they are interested in international arbitration, because all of these moot courts are essentially people volunteering their time, giving up their time, committing to these things. They often require a lot of commitment. My students will be doing anywhere between 10 to 20 hours a week on moot court, preparing memorials, discussing arguments, training advocacy, doing practice moots, etc., before they get to the real thing. So you can't be that committed unless you're that interested. So you're going to meet all these people when you go to Vienna, when you go to Hong Kong, wherever the moot court is. And then you're also going to see firsthand what a civil, if you come from a common law jurisdiction, what a civil lawyer, how they organize their arguments, how they adapt, how they present, and vice versa. And you're going to see a whole bunch of variety. So if you go to Vienna, for example, there is approximately I think there was 420 teams this year from all around the world, not just civil and common law, but you have Sharia law jurisdictions, you have all sorts of other jurisdictions as well. So you get a good variety. That's a good grounding to, at the very least, determine whether or not you really want to do this as a career.
Thank you for that, Frederico. We've got a very, very intriguing question for you in the chat box, which is, and this is smart because it doesn't talk about arbitrators and it doesn't talk about, counsel. It talks about the end parties, your clients. So from the business perspective of things, what seems to be preferred? The civil law setup, common law, and since you've mentioned different sectors in arbitration, are there any particular sectors where you see that there is a strong tendency to prefer one form of legal tradition over the other?
So I think in terms of parties, if I break that up into two sections, in terms of parties and clients, I think parties and clients tend to feel more comfortable in the legal tradition in which they are located. So, if you have a French company, I suspect they will feel more comfortable with a French leaning. I wouldn't even say, civil law leaning, but French leaning procedure, laws, etc. And if you have a New York company, I think they would prefer a New York type procedure. So, people feel more comfortable with what they're familiar with, and that tends to translate into an international arbitration as well, I think. And I would say, advocates, counsel have a big influence on that as well. So if you have a firm representing a client from a particular jurisdiction, then they will want something as familiar as possible. And I think that probably plays back again to what I said about the fact that if we have the first generation of students or practitioners who are coming from and have studied international arbitration, then what you have is a whole legacy, and the most senior practitioners will still probably have studied litigation, and that's what they're used to. So that's number one. So I don't think there is one answer. I think, you go with what you know. In terms of sectors, I think that very much depends. There is a lot of regionalization. So even within sectors, if you take construction, for example, first of all, who are the parties? If you have a state party, then there may be some mandatory regulations which require it to enter into contracts, concession agreements, etc., under specific laws, under specific procedures, even if that involves international arbitration. And then again, certain areas, I would say, obviously being an English practitioner, an English lawyer, I deal a lot with English law, and I know that there are certain sectors that are heavily influenced by English law. Examples of these are things like insurance or maritime. International maritime law is effectively English law. There'll be in insurance, you'll have lots of Lloyd's syndicates, especially on reinsurance, and therefore you get a lot of English law contracts. Even construction, if we look at the sort of standard, large international standard form contract, the FIDIC models, although FIDIC is effectively French organization, it is, or European organization, it is, the models are very much taken from English contract law. So I certainly see a lot of that, a lot of financial sectors, you might see New York law, for example, but I think there is some level of regionalization as well. So in terms of sectors per se, there are some obvious things where I think you may have common law influences. Having said that, that's not always the case. So for example, if you get a lot of Middle Eastern contracts, you may have Sharia law involved, and therefore that's a very different thing. And you have different rules, such as you can't charge interest, et cetera, et cetera. So it's going to vary, I think. In sectors, there are some tendencies, but I wouldn't say there's anything across the board. If there's one thing about international arbitration, I think, is that you get everything. And it can be, every single arbitration is completely different and a different mix of laws, cultures, etc.
Thank you so much for that. And I love how much of that answer was just common sense, in the sense you're going to be more comfortable with what you're familiar with, but also the kind of vast differences that you've outlined for us within sectors, where there's a lot of regionalism. And again, even standard form FIDIC contracts, European body draws from English law, maritime seems to be entirely English. I think those are all very important pointers for us to bear in mind. And thank you so much also, Frederico, for when you were speaking about construction contracts. So it brings light whether this is against a private party or the state. And while this is strictly not on topic, I'm going to link it to some of the earlier questions we received. Would you mind, for our young learners here, shedding a little light in terms of the difference that we have between commercial arbitration, wherein it's usually a private contract between parties, maybe a state, versus arbitration emerging out of, for example, a treaty breach and not just a contract breach? Because I think at the end of it, that's what a lot of the questions seem to be hinting towards. If you would like to, shed some light.
Sure. Okay, so I think it goes back to what I said, that there is no single court that has jurisdiction across the world, that has global jurisdiction, right? So if you have parties from different countries, they have a choice. So let's take it simply. Let's say you have a Nigerian party and a French party, and they want to trade for something. Let's say Nigeria is selling a commodity. Let's call it lithium, right? They mine lithium and they sell it to France. We're going to make batteries for whatever electrical gadget or car or whatever that they're going to create. So in that situation, the parties will enter into a contract, and that's a private contract between two private entities, and they have a choice between either choosing Nigerian law or choosing French law, and resolving their disputes either in France, in the courts of France, or the courts in Nigeria. Either of those options will give one of the parties a greater advantage, the home advantage that we just talked about, right? So either the Nigerian party will have to go and hire foreign lawyers, which it is not familiar with, and go through a process which it is not familiar with, and run the exchange rate currency fluctuation risk as well. It'll have to bear that, okay? One of the parties will have to do that. The third option is that they can go to a third country. They could choose London or New York or Mumbai or wherever they want. And that means both parties are disadvantaged, right? They both have to run the currency fluctuation exchange. They both have to go to a system which they're unfamiliar with, and they both have to hire lawyers, etc., and all of that. So that's not a ideal situation. And so international arbitration serves as a way, a mechanism, which is not perfect, but in the absence of a better system, is the best system for resolving these international disputes. Now that's with private parties. We also have, because in the absence of an international court that has jurisdiction across the world, we have state entities. Now, what we haven't mentioned is state versus states. So we get arbitrations that are state versus states, and they're things like border disputes. Now, what happens when, you know, the Kingdom of Spain has a border dispute with Portugal, for example? Where does a state go? Is the state going to be adjudicated by a Portuguese court, or is a Portuguese state sovereign going to abide by a judgment of a foreign court that has no jurisdiction over it? How does that work? That's completely unworkable, really. So international arbitration steps in for that, and therefore they cede their authority, because arbitration is a mechanism that is completely founded on consent. So if the parties consent to these 2, 3, 5, 10 people, whatever it is, deciding and being bound by that, then that's a mechanism that functions, and therefore it takes it away from any particular nationality. It preserves their sovereignty and allows them to do that. Same with investor state. So you have one party who is an actual state. So instead of subjecting themselves to the jurisdiction, if you have an investor, and this is something that has happened recently, let's talk about all the solar technology, solar energy arbitrations against the Kingdom of Spain, as I've already mentioned it. So the Kingdom of Spain wanted to develop and wanted to be the front runner leader in solar technology. So they made a very attractive package in terms of taxation to attract foreign investors who would come and set up solar plants in the Kingdom of Spain and develop PV technology, photovoltaic technology. So after some time, they changed their taxation regime, the tariff regime, and therefore a number of these investors, you can imagine that something like photovoltaic technology requires a large scale investment in the billions, right? So a slight adjustment in the tariff system can cause a lot. These are long-term investments which require a lot of capex, a lot of capital expenditure to set up, etc. So therefore, these kind of variations in tariff regimes can cause huge variance in the amount of return that those investors get. So the way that investor states, or ISDS arbitration works, ISDS being investor state dispute settlement, works is that you have treaties between countries. They can be either bilateral or they can be multilateral. Multilateral treaties are things like World Bank treaties, the ECT, which is the Energy Charter Treaty, etc., where various countries sign up to it. And what it says is that it'll give protection to an investor should they invest in a particular country and the government makes a change, which adversely affects them, right? So one of the requirements under these investor treaties is normally that they are treated fairly and equitably. So the fair and equitable treatment requirement is normally something that's present in all these treaties. So what do you do if you're an investor and you allege that the state, host state, has not treated you fairly? Do you then have to go to the courts of that state, bearing in mind that a lot of states appoint judges and control the judiciary. The judiciary is normally one of the three powers of any particular state. So are you then going to seek redress for what you allege to be a wrong of the state to the state? That, at the very least, in some states, may not be ideal, right? So, and then do you go to your own courts? Does that mean that your court's going to adjudicate over a foreign state, a sovereign? Can you imagine the court of Mumbai issuing a judgment against the Kingdom of Spain? How's that going to be enforced in Spain? That's probably unlikely. So arbitration is a mechanism which allows these kind of disputes to be resolved in the absence of any other system that works. So I think that's part of the popularity of arbitration, is that there is nothing else.
And I think that's such a key thing to point out, because in the way I would say most of us are introduced to arbitration, it's a form of alternative dispute resolution. But when it comes to investor versus the state, as you rightly shown, there isn't any other alternative at all. It's arbitration or nothing. So that's quite interesting. And earlier in our conversation, we touched upon the different ways in which the common law system and the civil law system look at, for example, standard of proof, the burden of evidence. We've got a very interesting question, and this is interesting even more so because it's still a developing area in arbitration, which is, what is the approach that most common law jurisdictions versus civil law jurisdictions have taken to the issue of third-party funding in arbitration?
Yeah, thanks, Romit. I'm not sure that is necessarily a civil versus common law jurisdiction issue. Most common law jurisdictions have had an influence from England and Wales. Obviously, England and Wales was the birthplace of the common law, and therefore common law jurisdictions tend to be former British colonies or current British colonies, etc., part of the Commonwealth. And therefore, under English law, third-party funding was criminal. It used to be champity and maintenance, and then there was a legislative change in order not to make that a crime. It is still technically a tort, or it certainly can be a tort. So third-party funding is the funding of a cause of action, a party to bring a claim for a cause of action, which has nothing to do with that third party. I summarize that, of course. It's a bit more complicated than that, but simply put, that's what it is. And so where that third party is influencing the party who does have a claim, the reason champity and maintenance exists is because it's to discourage terrible claims being brought purely because the third party has an interest in instigating that claim. So that's why it was illegal, and that is still a tortious act. So the third party funder should be separate. Now, so in a lot of common law jurisdictions, there is still a legacy of champity and maintenance. So for example, the Republic of Ireland still has a law against champity and maintenance, which is criminal, and therefore third party funding is illegal, despite the Republic of Ireland being a common law jurisdiction. And many others have changed. So Australia is very liberal in terms of third party funding. England is liberal, and the US is very liberal. But there are other jurisdictions, like I've just said, in the common law, such as Ireland, which are not. Now, when we come to the civil law, those notions of champity and maintenance are not the same. They're not as prominent. And so certainly what I've found in terms of third-party funding in civil law jurisdictions is that they generally tend to have gone under the radar because it's never been illegal. It's never been really properly thought about necessarily. A lot of third-party funders have operated, and the courts have never had to deal with that issue. So unless something goes wrong and it gets before the courts, And obviously, because they're civil law jurisdictions, a lot of it is legislative, a lot of it will be in a code. And so there'll have to be a problem, it'll have to be come to the light, it'll have to be illuminated in a court, and then there'll be a legislative provision. Having said that, we've reached a point, I think, where a lot of third-party funders are in a position, especially the international ones, where they operate relatively professionally and well, and therefore the likelihood is lesser of the need arising to legislate, to regulate third-party funders. But this is, I think, a polemic issue which varies hugely from one jurisdiction to the next, irrespective of whether or not they're common or civil law.
Thank you so much for that, Frederico. What I'm going to do now is I would request our dear audience to go ahead and put in any follow-up questions, if any, for Frederico, into the chat box, and we will take them up to wrap the session. But otherwise, the last question from me is, in these two different legal traditions, civil and common, could you give us an example of, say, one practice each that you would like to see more of in commercial arbitration? Something that really works well in the common law system you would like to see more civil lawyers adopt, and vice versa, perhaps.
Sure, thank you, Romit. Yeah, the one thing, as a barrister, as you said earlier when you introduced me, who works a lot in Brazil, one of the things that the international arbitration world has embraced is the oral testimony and cross-examination of witnesses. And I think first of all, there is a misconception from many civil jurisdictions and international practitioners generally. I think a lot of people misconceived believe that the common law places more weight on oral or testimonial evidence, and that civil lawyers place more weight on documentary evidence. I think all practitioners, all jurisdictions, certainly that I've had experience of, place more weight in documentary evidence. And the reason for that is, of course, documents don't forget, they don't lie, they don't make mistakes. What's in the document's in the document. Of course, that document can be false or forged, which is a different issue, but what's in the document is there. But in a lot of cases, by the time you've got to a dispute, and that dispute, parties are spending significant sums of money to resolve that dispute with their lawyers, with the arbitral institutions, with the arbitrators that are appointed, with experts, with everything else. The documents don't always tell the whole story. And so, there'll either be gaps that the documents simply don't fill, or there'll be context, which is relative and important to the resolution of the dispute, which the documents don't tell. And those gaps are filled by testimony. And therefore, that testimony can be vital in making a factual finding one way or another to decide the dispute. And that's where I think the distinction lies. I think, again, speaking generally, civil law jurisdictions have more of a tendency to disregard the value of cross-examination and testimonial evidence, or certainly do not place the same weight, whilst I think common law jurisdictions recognize that there is that element which is important. Also, in terms of hearings, evidential hearings, the testimonial evidence is the stuff that takes the longest time, and it's often witness statements, which are predominantly used as evidence in chief of witnesses these days on international arbitration. They tell the story, they bring the case theories alive, they bring the disputes alive, they contextualize, humanize. It's a persuasive instrument for arbitrators to absorb the information via witness statements and cross-examination. So I think it has that utility, and I think civil law leaning jurisdictions perhaps don't understand cross-examination and are not trained to execute cross-examinations as well. And I would like to see more of that, because I think actually it's a fundamental part of international arbitration. I think international arbitration has been influenced by the common law, so that cross-examination is a fundamental part of most evidential hearings. In terms of civil law, when it comes to things like disclosure and evidence, documentary evidence, I think the current system, or the general current system, which is to disclose the evidence you rely on by way of your memorials, and then to have a red phone schedule to make effectively specific disclosure requests afterwards, is quite civil law leaning. What we tend to do in the common law is to just draft what we would call pleadings, which is effectively our case, cause of action, facts that build that cause of action, and the remedy that we seek. And then all the documents are disclosed later. And another distinction is, of course, in common law, I think we have more of a tendency to have a requirement to disclose adverse documents as opposed to only those that assist our case. And I think the memorial system is more towards the civil law. So I think that already exists, but I think it's quite effective. So subject to, again, the utilizing the flexibility that our international arbitration affords, tailored for specific cases. In general terms, I think those are my observations.
Thank you, Frederico. To wrap this up, I'm going to plug a few questions that we've got from the audience. And we have a question regarding standardization and then laws of evidence apply quite strictly. So I'm going to go back to where we started in the webinar. And you mentioned that there are various soft laws like the IBA rules on evidence. And similarly, I think we've got a competing set of guidelines from Prague. So how does this quite work out, in the sense the arbitration procedure itself is flexible, but are there any form of standardizations that are followed? And within that, how competitive are these different standards that are being propagated per se?
Yeah, I think there are attempts, and I think that there is, first of all, I'd say probably there isn't a standard, even though we sometimes use the word international standards. So I think that's a fallacy. I don't think there is a single standard, and I don't think there is two arbitrations I've ever done in over 250 in one capacity or another that have been the same. They're all different in the international context. And certainly the procedural rules are normally made up of the mandatory provisions of the local, the law of arbitration of the seat, the lex arbitri, together with any institutional rules that apply, and then all the procedural orders, right? So that is the rules of civil procedure, if you like, for that particular arbitration. And when you have different parties from different cultures, you have different applicable substantive laws, different lex arbitri, different institutional rules. Every combination, and then all the provisions that are either agreed by the parties that go into the procedural orders or decided upon or mandated by the tribunal, that combination is always different. If you had to codify that and write out what the procedural rules are in some kind of civil procedure code, every single arbitration would be different. So what do the harmonizations do? Certainly, if we take the IBA rules on taking of evidence, for example, what I tend to see a lot in international arbitrations is that there'll be, in procedural order number 1, a paragraph that says the tribunal shall be guided by but not bound by the IBA rules of the taking of evidence, right? So it's a protection for the tribunal to say, if we decide in accordance with the IBA guidelines, then you can't criticize us for it, but we're not bound by And that's the kind of thing. Then you have, the Prague rules, for example, that came to say, actually, the IBA rules are a bit too common lawish. Let's have a more civil lawish approach. And now we have the revision of the IBA rules of taking of evidence to respond to the Prague rules. So it's an ever developing, ever changing scenario, I think. But I don't think there is a single international standard, and I'm not sure there can be, really, just because of the variety that you get in international arbitration. It has to be on a case-by-case basis.
All right. With that, thank you so much, Frederico, for quite literally taking us on a case-by-case understanding of not just, of course, commercial arbitration, but touching upon the ISDS and walking us through these incredible nuances within the civil and common law systems. I mean, we know that the basic difference is one runs on court, the other is precedent, but with the nuances in terms of what is the standard of proof, and you round that up right now in terms of the different approaches towards evidence, I think that gives all of us a lot of food for thought. Thank you also for bringing in practical insights from different sectors in which arbitration is practiced, the preferences that we see there for particular forms. We really, really appreciate you taking the time, engaging with all of our IAMC members. And to our audience, thank you so much for coming. And I'm glad to see, at least based on the names we have, that we have gone beyond the usual sign-ups from India. So thank you for joining us from your respective time zones. We appreciate the time and commitment. And yes, everybody will have access to the recording for this. That's going to be uploaded to our YouTube channel in a day or two. Thank you very much. Thank you for sitting through all of this with us, being a part of this. And thank you for such lively engagement. Frederico, thank you again for going above and beyond your brief, really. We appreciate the time and absolutely the breakdowns you've given of the differences. Thank you so much.
Thank you, Romit, and thanks for everyone who's been watching, and thanks for the organisers, IAMC especially. It's been a real pleasure to be here, and I hope it's been as interesting for you as it has for me.
All right, thank you so much, Frederico. We'll call it a day. Thank you.